Welcome to our webinar, Separate Ownership of Energy Resources, or Can you Sever in a State in Blank? I'm Ryan from Pizzuli, Program Manager of the Institute for Energy Law, which is an institute of the Center for American and International Law. This webinar is hosted by IEL's Academic Outreach Committee, and this is the first of two sessions we have planned this summer on energy transition academic topics. I would now like to welcome our speaker, Professor Joseph Schremer. Professor Schremer is an Associate Professor of Law at the University of Oklahoma College of Law and Director of the Oil, Gas, Natural Resources, and Energy Center. He teaches courses in oil and gas, energy, and natural resource law, as well as first-year property. He has published on topics such as correlative rights, waste, property and pore space, subsurface trespass, and split estates. He is also the Vice Chair of IEL's Academic Outreach Committee and helped to spearhead this webinar series. I'll pass it over to Joe.
Thank you, Ryan, and thanks to IEL for the opportunity to spend an hour with you over lunch today. The theme of these webinars, well, really two overlapping themes. One is that they're academic, which I take to mean that they are intended both to teach and to sort of take an expansive view of our law, consider it maybe from a broader point of view than what you normally do in day-to-day law practice. And the other overlapping theme, at least for these most recent webinars, is the energy transition. So I am admittedly and proud to be an oil and gas lawyer, just an old-fashioned dirt guy, basically. And so the approach that I'm taking to the energy transition topic here is a property law approach, just like the transition from coal and whale oil to oil and gas. The transition that we're experiencing to zero carbon, green, renewable energy transmission and generation is, at least in part, a big property law question. So today's presentation focuses on one particular aspect of that property law question, and it's frankly a pretty fundamental aspect, and it's ultimately the question of what sorts of property rights, if any, can non-landowners obtain in the elements of the earth, the physical stuff that we use to generate energy in this transitionary moment of ours. So let's set the table here by talking about what is the stuff that makes up our new energies in the energy transition. Fundamentally, setting aside only nuclear, basically all of the novel technologies that we are able to use to generate energy other than from fossil fuel sources require some element of land, or at least some physical element to accomplish. So here's a sort of graphical depiction of some of the most prominent of those natural resources. You've got pore space, which is not really there for energy generation so much as it is for the storage of carbon dioxide that's emitted from combusting fossil fuels in the process that we call CCUS. Certainly an important part of the energy transition and our approach to climate change. Below that, obviously, you have depictions of a wind farm and a solar farm, which use the physical elements of wind and sunshine in place on a particular tract of land to generate renewable electricity. In the upper right-hand quadrant there, I'm trying to depict geothermal energy generation, which uses naturally occurring heat energy in the deep subsurface of the earth to generate electricity without carbon or methane emissions. There are others that we could talk about. Hydrogen is one. Some hydrogen is found in natural subsurface deposits. That would be another example of a clean natural resource that we could use for energy in our transition. Another one, even still, would be lithium, situated in solution in brine waters that obviously is extractable and refinable to make things like batteries. So the list of possible resources that this topic would apply to is very broad. And we're gonna talk a bit about some specifics. We'll talk a bit about pore space specifically, a bit about wind specifically, but the general overview here should help us to understand sort of the broader legal context of the estate severance question across all these novel natural resources. So before we jump into it, let's talk about what that topic, that legally speaking, what that topic consists of. Basically, what we're asking is a private law question. It's about ownership and rights to develop these various natural resources. At the very basic level of who owns these natural resources when they are in place, before they have been extracted, the answer is generally through a principle that we call ratione soli, by reason of the soil. We place ownership of these things in the landowner. So the owner of a parcel of land enjoys, by virtue of that common law ownership, ownership also of the constituents of the land, things like pore space, things like geothermal energy, most likely, unless it has been severed off permissibly into ownership by a third party who's not the landowner. Now, the severing off of the ownership of it, that's a matter of separating title to the natural resource from title to the land where it originally rests. And it's a question of law whether and to what extent ownership of those resources can truly be severed from ownership of land. Which, to phrase another way, to sort of frame what we're doing here, you might also, or instead, ask, what kinds of legal interests might the owner of land, assuming that landowner owns these resources, or has whatever property rights the law will recognize in these resources, what kinds of legal interests might that landowner convey to third parties who don't own the land? And we won't have a slide on this because it's such basic property law, but if we wanted to think about it like a menu, the menu of potential legal interests a landowner might create could include things like leases. Leases as in landlord-tenant or occupancy leases that grant the tenant or the lessee possession of the land and use of certain natural resources like the soil to grow crops for a limited duration, while the ultimate ownership and right to possession and right to all the natural resources, at least the non-renewable ones, rests in the lessor in its reversion. It could mean an easement. That's a type of legal interest that could be created. An easement is really just the use, the right to use another person's land, and is not really considered ownership of any particular element of the land. So if you have an easement to build wind turbines on a landowner's tract, that doesn't mean that you own the wind or own the land where the turbines are set, but merely the right to occupy it for a particular use. But that's a legal interest that we could imagine being on the menu. There's a legal interest called a license. A license is a privilege of a person to enter the land of another. It is hardly even a property interest the way that an easement is, because it is typically revocable, unlike an easement. And it also, like an easement, doesn't entitle you to claim any of the resources on the land. You're just there. You're just receiving a privilege to enter the land without trespassing. The two that are the last two menu items here that we're really going to focus on in this lecture, because they really constitute severance of ownership of a property entitlement to these natural resources themselves are first a profit or a profit a prandra, which is at common law like an easement, gives you a right to enter someone else's land, but unlike an easement, allows you to take away some resource, which effectively means that the holder of a profit has something like an estate, a right to own or a right to extract that resource that distinguishes it from an easement. And then, of course, you have the potential last menu item of the landowner being able to grant fee ownership, an actual possessory estate in the resource, equivalent to the estate that the owner has in the land itself. And so these are the menu options that landowners potentially have to choose from in granting the rights to exploit these natural resources to third-party developers. But the question is whether the landowner is really free to choose any item on that menu in a jurisdiction where there is no precedent, in which the jurisdiction, either through a judicial decision or potentially through legislation, has specifically recognized the right to convey these kinds of property interests in the natural resource. As we go through the lecture, you'll notice that it's even a question whether a landowner needs the express permission of the law through statute or an enabling precedent in a case in order to do this, or whether they're free to do so. But that's part of the question that we are trying here today to unravel. To unravel it, I want us to sort of think like a lawyer who's, at least initially, who's in the position of advising a landowner client about whether and what kinds of interest the landowner client might create in any of these novel natural resources. How would you start to answer that question, at least in a jurisdiction where it hasn't been answered by precedent or an applicable statute? I think you would start by looking for analogies in the law. And the most obvious analogy is oil and gas, because we had precisely the same question before us when we discovered oil and gas in commercial quantities in parts in jurisdictions across the United States. And so we had to answer the estate severance or property severance question for that particular novel resource. How did we do it? Well, let's take a look in the early era of oil and gas law at the birth of the severed oil and gas estate. The first thing that you'll notice when you take a look here is that the question was resolved judicially and not legislatively in those days, although I wouldn't doubt that the legislature has the power to define what kinds of property interests might be conveyed apart from land in a particular natural resource. At least in the case of oil and gas, this is a purely judicial process. Here's how it unfolded. And the research that I've done has looked extensively at the cases, but also the treatises, the early treatises in oil and gas law of the time. The reason it was necessary to look at treatises is because the case law is perhaps surprisingly pretty thin. There are not a lot of cases from the 19th or early 20th century of courts expressly adopting or recognizing the right of a landowner to sever off ownership or property rights in oil and gas resources. And I was curious about why that was. And I think that the early treatises, and I also on the next slide have an early case book, they sort of give us a glimpse into why that is, why the courts were not particularly loquacious on the point. And it starts simple. It's sort of a syllogism, really, with this first premise. And here we're looking at the premise as expressed in the Brine treatise, which, as far as I can tell, is the first real oil and gas law treatise. Brine says, citing cases, in mineral lands, the surface or soil as adapted to cultivation may be separated from the mineral right or the right to dig under the surface for ore, and one person may own one of these rights and another person may own the other. Note that what Brian is talking about here in the cases that it's citing are hard rock mineral cases. Think about the example of coal. And certainly the case law there was already well established that you could sever either a fee estate in coal, or if you preferred, you could sever a profit a prendre in coal, separate and apart from the right to the land. That doesn't quite answer the oil and gas question, though, because oil and gas are not coal. The early treatises, though, do answer that question by this mechanism. It's not quite analogy, but it's something similar to analogy. The early treatises, and in fact, the early courts do this the exact same way. They take the principle of hard rock mineral severance and they apply it to oil and gas on the theory or the classification of oil and gas as a type of mineral. And so if you had precedent in a state, for instance, the state of Pennsylvania, that permitted landowners to sever a fee estate or a profit in coal because coal is a mineral, all that you had to do in those states was classify oil and gas as a mineral, and suddenly the coal precedent becomes precedent for the severance of oil and gas as well. And that's the sort of reasoning that predominated in, at least in common law courts. We'll see that that was a slightly different case in the civil law jurisdiction of Louisiana. But in common law courts, that's basically the process that we followed. We don't really focus on that. When I teach oil and gas law, we don't spend any time at all on that question. We just assume the truth of it. But what we focus on instead are all of the sort of second order issues or the consequences, legal consequences of allowing severance of property interests in oil and gas as minerals from ownership of the land. And there's a bunch of those issues. And if you've taken a basic oil and gas law class, that's essentially the structure of the class, is dealing with all of the consequences that flow from severance of oil and gas rights. The sort of basic ones here that we don't spend a lot of time on in oil and gas law anymore because they're so well settled by precedent, but at an early time were extremely uncertain, important, and controversial, are these that we often associate with A.W. Walker in the early Texas Supreme Court because it was his scholarship in those early Texas opinions that really fleshed these out for us. And we sort of still follow the reasoning that Walker lays out in a series of influential articles from the 1920s, I believe. One is, if we allow, and which we have, severance of oil and gas, how do we know when the landowner, through an instrument, is intending to sever the oil and gas, or instead just lease the oil and gas in an oil and gas lease? And in fact, related to that is the question, well, what is an oil and gas lease? Is it ownership of the oil and gas? Or is it some kind of a lesser interest? Is it a landlord-tenant lease, for instance? Now, of course, if you know oil and gas law, you know that the courts eventually determine that the lease is sort of a sui generis property interest. It's unique. It's its own thing. It's neither a landlord-tenant lease nor truly a deed of the ultimate ownership rights in the oil and gas. And that for that reason, it's distinct from a deed of the oil and gas. Another major question, of course, was how to classify for legal purposes the legal interest that you get when you take a deed of oil and gas or a lease of oil and gas. And so that's where you get into the question of whether you can truly own oil and gas in place or whether you merely have a right to extract the oil and gas in place. That translates to whether the severed interest is classified as a fee estate or merely a profit, a right to enter and take. All of that filled the oil and gas law case reports and law journals for the first few decades of oil and gas law development. But since then, we've really been focused on a different set of consequential follow-on issues from the determination to sever. And those issues are still very important in mineral law practice today. And to some extent, all of these issues are the result of, or their importance is highly exaggerated by virtue of the fact that the the ultimate right to extract the oil and gas can be severed from the surface of the earth. So what am I talking about? I'm talking about use of the surface by the holder of the severed oil and gas estate or lease in order to develop and enjoy the underlying minerals. That has been a huge problem throughout oil and gas and in mineral law generally, trying to regulate through principles of property law the correlative use rights of surface owners and subsurface mineral owners. And it's been such a problem that it's been such a fertile source of dispute that many states have tried to remedy it with some remedial surface damage or surface owner protection legislation. And so part of the reason why those are such controversial issues oftentimes is that the severance of minerals means that the developer of the oil and gas has no interest, and really, apart from its right to use the surface, no relationship with the surface owner, and the surface owner has no interest in development of the minerals and really no relationship with the mineral owner, and so it's rife for dispute. There's an additional set of problems that occur in certain parts of the country where different different minerals, I should say, like coal, oil, natural gas, coal bed methane, potash, can all be severed into separate ownership apart from the surface. Now we have the clash of interests of separate severed estate owners, the coal versus the oil and gas, or the potash versus the oil and gas owner. And this has caused a huge amount of common law controversy and has been dealt with legislatively in the states in much the same fashion as surface use has. Well, mineral owners are also painfully familiar with the issue of title fragmentation to the severed rights in oil and gas. You see, unlike land, which is really convenient to use only when there's a handful of owners of the land, if you have too many co-owners, it just becomes almost useless because there are so many potential opinions that matter about how to use it. When it comes to minerals, fragmented ownership is a lot more makes a lot more sense to people because it's really more like an investment. It's an economic interest more than a place where you might build a home or put up a campsite. It doesn't have sentimental value. So mineral ownership tends to fragment at a much higher rate than the ownership of land does. And that fragmentation means that for any particular parcel of land to develop the oil and gas, you probably need to get, if not legally, then at least economically and practically, you probably need to get lots and lots of different fragmented mineral interest owners on board with the idea of developing it, and that can be highly difficult. And so we have a huge amount of mineral law practice that's dedicated to just getting everyone leased up. And we have a lot of legislation in the states to deal with the problem of it being impossible to locate or lease everybody who owns a right to develop minerals. And so here's a handful of the major examples. Compulsory pooling statutes are really intended to deal with that fragmentation issue. We have states that have dormant mineral or mineral lapse acts where unused mineral interests can sort of revert and rejoin title to the surface estate under certain circumstances. If you practice at all in Ohio that has a dormant minerals act, the chances that you'll end up with litigation over how that statute applies is very great. So those questions really dominate some of the reported cases that come out of states that have those statutes. Another problem that's not as obvious, but it doesn't fall on any particular individual owner or interested party, but it's sort of shared by society as a whole, is this idea or this problem of measuring costs. Here's what I mean by that. When a jurisdiction recognizes the power of a landowner to sever off an interest in a novel natural resource, so jurisdiction decides you can sever oil and gas rights. Now suddenly, for anybody who's interested in buying an interest in land in that jurisdiction, one of the things you have to consider before purchasing is whether that land that you're trying to buy also still enjoys the right to exploit the oil and gas, or whether it's been severed. In other words, you have to determine whether the land you're trying to buy is going to be subject to this newly recognized severed estate. And so suddenly you have a heightened duty to do some basic title examination and investigation over the baseline of what you would have had to do in the world before the novel severed interest was created. And so it may not be a big deal in any particular land transaction. It may mean just a little bit more time doing title examination, a little bit more expense by the buyer, but multiplied over every title transaction in that jurisdiction for the rest of history, the social cost of that can be quite significant. So these are all sort of consequences of severance that probably the courts didn't have in mind. Certainly, they were not talking expressly about when they decided that oil and gas as a mineral is obviously severable like any other mineral. I mentioned earlier that the severance question has been dealt with in a slightly different way in the civil law jurisdiction of Louisiana. And so let's turn there to get sort of a counterpoint to oil and gas law severance in every other jurisdiction that follows the common law. In Louisiana, it's a civil law jurisdiction, which means that the source of law is not judicial precedent, but rather the civil code. And a corollary of that is that ownership rights or property rights are defined by the code and only defined by the code. They can't, new forms of ownership, new types of property cannot, in a true civil law system, be recognized purely by judicial precedent. It must come from the code. And so that general principle in the civil law is referred to, at least in the scholarship, as numerus clausus. It means that there's a fixed set of forms of ownership recognized by the code that cannot be added to by a landowner who wants to invent a new form of ownership. It has to be expressly authorized by the code. So this has real consequences for mineral severance, because if you think about oil and gas severance as a new form of ownership, a new type of property interest that's not previously recognized, then in a civil code jurisdiction, landowners are not free to just convey an ownership interest in the oil and gas under their land, because it's not a recognized form of ownership. And so they can write a deed that purports to do it, but the legal effect will be that the conveyance is either invalid or that it takes on the character of a interest in land that has been recognized. So in the Civil Code of Louisiana at the turn of the century, there was no express recognition of a severed interest, a severed ownership interest in oil and gas. But what was recognized in the Civil Law Code was the idea of a servitude, which is sort of similar to an easement in the common law system. So you could convey servitudes, the right to enter the land of another and take some oil and take some natural resources like minerals. But you couldn't, without the legislature convening and expressly authorizing it, you couldn't sever an ownership interest. And in the case of Frost Johnson versus Sallings heirs, which was actually highly controversial, it was heard 3 separate times on rehearings by the state Supreme Court. The state Supreme Court ultimately held that the Civil Code didn't recognize severed ownership of oil and gas. It only recognized the right to create or convey a servitude in minerals. Now, the thing that meant, the sort of corollary to that was, like all servitudes under the Civil Code, the mineral servitude was only valid for 10 years, and that so long thereafter as it was used within the meaning defined in the code. And after 10 years of non-use, all servitudes lapse. And this is an immutable rule of servitudes in the sense that a landowner cannot draft around it. A landowner cannot create a servitude that is not subject to this lapse by prescription. We kind of refer to that as the doctrine of liberative prescription. And so that means in Louisiana, unlike in every common law state, the maximum type of property interest a landowner can create in oil and gas is a use limited servitude, limited by prescription, and not a perpetual. In other words, an interest that could go on forever, regardless of whether it's ever developed, a perpetual ownership interest in land. Before we leave the point there, I want to look granularly at the Frost-Johnson case, just at this particular question of how did the Frost-Johnson court reason its way to that conclusion? Well, the primary way it reasoned its way to that conclusion is it said, we don't believe that you can own oil and gas. We don't have the concept of oil and gas ownership in our civil code or our civil law traditions. We think that you only have the right to access the land to try to exploit the oil and gas. And so that means that what you can have is a servitude. So there is sort of the formal mode of reasoning. But in addition to that, the court was also concerned with sort of the consequences of the decision whether to recognize perpetual ownership of severed oil and gas versus only a use limited servitude. And here, Justice O'Neill, whose opinion ultimately became the majority opinion in the case, but in this particular rehearing, he was writing in dissent. Here's what he says. This is important, I think. If we were to, and I'm really just focusing on the bolded language here, if we were to allow perpetual severed ownership of oil and gas, it would tend to paralyze the oil and gas industry of the state because it would recognize a species of perpetual encumbrance upon real estate, which has never yet found an abiding place in our civil law system. The court here was saying, we don't want a perpetual interest because we think that giving someone the right to the oil and gas separate from the land perpetually with no obligation or incentive to develop it could result in them just sleeping on their rights and locking up that oil and gas, making it hard to develop unless you can get the consent of that owner or somehow get it out of that severed owner's hands. And in fact, one of the primary rationale of the idea of liberative prescription that limits the duration of servitudes is to free land from those perpetual burdens in order to make it more developable in commerce. And so there was some substantive reasoning here in addition to the formal reasoning that supported the idea of limiting the kind of property right that a landowner can create in oil and gas in Louisiana. So now you know more than you ever really wanted to know, or have gotten a more thorough review of what you already did know about oil and gas law severance. I hope what you take away from that is the modes of reasoning and the important sort of consequences and implications of the severance question. As we turn now to look forward at how courts and legislatures are likely to address or are already addressing the question of severance of these sort of newfangled natural resources. And I want to start that by looking at pore space. Now, those of you who are in Texas, which I gather is probably most of our audience here today, you may be familiar already with the Dark Horse Water versus Birch Operations case decided by the Texas appellate courts a couple of years ago and currently on review by the Texas Supreme Court. We don't have an opinion out yet, so we don't know what the Texas Supreme Court is going to do, but this is the most important case in pore space severance to date. It is, we'll talk about it in some depth here in a moment, but it is the first case that I believe in any jurisdiction, at least that I've been able to find, that directly raises the question of whether a landowner has the power to sever a separate property interest in pore space. We do also, though, have this much earlier Colorado appellate court case called Bushy from 1975, which is an adverse possession case where the true landowner was storing natural gas, I believe, but I'm not positive, storing some kind of substance for beneficial purposes in the pore space under her land when the surface of it came into possession of an adverse possessor the court determined that the adverse possession only took prescriptive title to the surface, but left title in the subsurface pore space with the true owner, because subsurface pore space was severable in the same way that oil and gas is severable. And so Bushy represents probably the earliest discussion ever of severance of pore space from land, and it ultimately decides that it's severable on the basis of an analogy to oil and gas. Okay, but let's look at dark horse, because it really takes on the question more directly. This is a quiet title dispute between two lessees of basically saltwater disposal leases covering the same interest in a tract of land in Texas. One holder of a saltwater disposal lease was Dark Horse, the other was Birch. One recorded its lease first, even though it took the interest second, and Dark Horse ultimately sued Birch to quiet title, claiming that it had the prior right to dispose of salt water in the pore space of the land. And Birch defended this on the ground that Dark Horse lacked the requisite property interest to bring a quiet title suit under Texas law. Under Texas law, you can bring quiet, in law generally, you can bring a quiet title action if you own title, which is to say you own an estate of some kind in the land. And so the question came to the Court of Appeals from the district court decision: did Dark Horse receive an estate in the land by virtue of its disposal agreement? Here's how the court starts. It says, this is our premise. Parties are free to draft novel contractual terms that produce results that some may consider to be odd, but the court's duty is to give effect to that intent as it's expressed in the contract's language. In other words, if the landowner wanted to, the landowner could create a contract to give property interests in any form or fashion or element of the land, and the court's job is merely to figure out what was intended and to give legal effect to it. So that's simple. We just have to look at the language of Dark Horse's saltwater disposal lease to figure out A or B. A, is it just a lease, like an occupancy lease that doesn't actually give an estate or ownership of the pore space to Dark Horse, in which case Dark Horse cannot sue to quiet title? Or B, does the language of the instrument indicate an intent to give title of over the pore space to Dark Horse, in which case Dark Horse can sue in quiet title? Looking at the language, it's an unusual document. It has some language that you find commonly in saltwater disposal leases, but it also has a lot more details about compensation and duration and operating rights that sort of obviously resemble, I should say, the terms of a typical oil and gas lease. And so the court, by analogy, says this is drafted just like an oil and gas lease. And in our view, the pore space is a resource, a consumable, depletable resource of the land, just like oil, gas, coal, gravel, salt water, that is capable of separate conveyance as long as the terms of the instrument intend to do so. And since they're drafted just like a lease, we're going to consider this to be the same kind of a conveyance that an oil and gas lease is, which in Texas is the separation of a fee simple defeasible, essentially, in the resource. And so the Dark Horse court holds that the intent was to create a determinable interest severed from the land in the pore space, and that intent was fully enforceable in law. Notably absent from any of the discussion in the Dark Horse case is the consequences of that, what that means for classification of the interest, things like surface use, etc. When we turn to wind, we have a little bit of case law, and it's going to be the sort of repeat of the pore space situation. A couple of cases here, much older than the recent Dark Horse case. Contra Costa Water and Romero. Romero kind of discusses the matter but doesn't take it on directly. Contra Costa does take the matter on directly about whether the rights to generate wind, so whatever kind of property interest the law will recognize in wind, whether it can be separated from ownership of the underlying land. So let's look at that one directly. The case involved, this is sort of an aside, but the case involved um, a sort of a water district using condemnation authority to condemn land for a water project. And the land was subject to, at the time, a wind farm and a wind farm lease agreement. And so the real value, economic value of the land was for its ability to generate rentals from the wind lease and not for the land really itself. And so the condemnation authority wanted to pay as little as possible. And it argued that it was only condemning the land and it was thereby severing off the wind power rights, leaving it in the hands of the landowner. And so therefore didn't have to pay just compensation for those rights. All right. And so the question was put to the court, can you sever wind power rights? And the court said, yes. Why? Analogy to oil and gas. Generating electricity from windmills is no different from the right to pump and sell subsurface oil, and that's fully severable. So the right to use the wind is fully severable as well. Basic analogy to oil and gas, not very different from the reasoning in the Dark Horse case or any of those old oil and gas law cases either. One thing that the Contra Costa Court did say explicitly in response to the landowners arguing, hey, whoa, it's actually a big deal because all those consequences that you and I talked about earlier, actually a big deal in a jurisdiction to authorize severance of a separate natural resource, separate from the ownership of land. And you need to think about consequences like use of the surface and conflicts with other mineral and water resources being developed on the same land. You need to think about those in crafting your decision about whether the interest ought to be severable or not. The court says, no, not only do we not have to do that, we are prohibited from considering those sort of likely consequences because we have a policy against resolving abstract disputes between mineral owners and surface owners and et cetera. So we can't consider it even if we wanted to. Okay. Now, I mentioned early on that the question can be resolved legislatively, of course, instead of judicially. And as it pertains to pore space and wind, several states have taken legislative action to resolve the question. And so this is sort of an alternative to letting courts just decide, which some states have taken. For pore space, we have a couple of states, Wyoming and Oklahoma, that have reasonably clearly, by statute, vested title originally to pore space in landowners, as opposed to mineral owners, and authorized landowners to sever off ownership of the pore space, essentially the way you could sever off oil and gas. So seeming to authorize the severability of a separate estate. North Dakota, interestingly, has a statute that prohibits the severance and separate ownership of pore space altogether. On the wind side, we've got a whole bunch of states that for many years now have prohibited the severance of an estate in wind, even though many of these would allow the granting of an easement to use the surface to capture wind. But at least in the legislative context, we see a lot more skepticism about the wisdom of severance of these resources than we see in the judicial opinions. So when legislatures weigh in, they tend to be constricting on the landowner's power to create whatever property interest they might want in a natural resource. But when courts do it, they basically use analogy, and it's sort of free-for-all for landowners. Okay. Now, why are legislatures so constraining here? I've done a little bit of looking at the legislative histories. They're pretty scattershot and piecemeal, but from what I can find, in every jurisdiction that had real legislative debate about it, they were concerned about things like surface use, conflicts with minerals, fragmentation of title, the separation of wind rights into the hands of speculators who never have to actually develop the wind, but can just sort of sit on it in hopes of a windfall profit in the future. Those similar kinds of consequences that we talked about earlier in the presentation. They were worried about those. Now, there is another alternative here, at least in theory. You could have very free, hands-off judicial opinions that operate by analogy. You could have very constraining legislation that could really limit landowners in what kinds of interests they can create. But of course, there's also this other alternative that courts could, through some kind of policy making or at least policy considering power, take a less hands-off approach to determining what kinds of interests a landowner might convey. And now, a lot of folks in the audience, and rightfully so, in my opinion, ought to sort of tense up at the suggestion that courts should be doing more policy making in this realm. Because we think of policy making as being a legislative and not judicial function, and being very dangerous to give courts sort of freewheeling access to policy making authority. What I want to do with the remainder of our 15 minutes here is make a scholarly argument to you that courts, common law courts at least, in fact already have this sort of policy making authority on the question of introducing new property interests into our common law system of property rights, and that there are sort of doctrines and traditions in place in that history that structure that exercise of policy-making authority, so that it's not a freewheeling deal that we can expect that courts will they will remain confined by the doctrines, relatively speaking, from just making whatever kind of political decision they might feel best. So the way I want to do this is by looking further back in our common law heritage beyond oil and gas, to severance decisions, judicial severance decisions mostly, that predate oil and gas. In fact, I want to start with looking at the severance of hard rock minerals, which of course is the body of precedent that courts were looking to as precedent for their early decisions in severance of oil and gas interests. So how did we get severance of a mineral estate in the first place? Here's what I found. Here's what I believe to be the case. It is ultimately a customary practice that the common law adopted legally. There's a custom of landowners having the right to sever off certain kinds of minerals in their lands to another to develop, at least, or to reserve to themselves when they conveyed away the land so they could develop it separately from the land. And this custom ultimately gained legal recognition. The first legal recognition ever of such mineral severance customs can be found in the Magna Carta in 1215. That's how old we're talking. And so it was one of those concessions that King John made to the nobles back in that great charter. Judicially, it came to be recognized ultimately in the 16th century in the case of mines, and then in Mountjoy's case, this custom of severing minerals, so long as they were not gold and silver, which in the case of mines were held to be part of the crown's estate, they could be severed off by the landowner. Now, we know from this that it's ultimately a matter of custom being recognized in the common law of property that we get mineral severance, but we don't get much from these old authorities about how common law jurisdictions, common law courts, decide to adopt the custom. Do they just adopt the custom every time they're presented with one? Is there some process, some doctrine that governs their adoption of custom? And in fact, there is. So if you fast forward to the 19th century here, we have a pretty famous case of a local custom. So this is a local custom that had long been recognized in Cornwall. There are similar ones in Devonshire, where a non-landowner could, almost by adverse claim, claim for themselves the right to mine tin or iron in Devonshire in another's land. And this local custom had never been adjudicated whether or not this local custom what created a separate ownership interest in the tin in favor of the tin miner. apart from ownership of the land? That question finally made it to a common law court, whether it's severed ownership of the tin in 1847 in Rogers versus Brenton. And the Rogers versus Brenton court gives us the old classical common law way of determining when the common law court will recognize a new ownership interest in property, here a severed tin estate, as a result of it being recognized already in a local custom. And it answers that question based on a doctrine that was popularized, sort of synthesized by Blackstone in his commentaries, although Lord Coke also talked about it in his commentaries on Littleton. And basically it goes like this. Premise number one: no new property interests may be created in land that haven't already been recognized in the common law. So there you might be hearing echoes of the numerus clausus principle from civil law. Two, we will, as an exception to that general rule of no new property interest, we will recognize new interests in land when there is an existing and reasonable custom giving effect to that separate new property interest in land. And so a common law court's job is to examine the custom for reasonableness. And how does the court do that? Well, here the court looks at basically a list of consequences of the severance, similar to the consequences we've been talking about of severance throughout this whole presentation, to determine whether or not it's reasonable in common law. And they decided that in the case of severance of tin, a perpetual severance, a perpetual estate, was not reasonable because it would keep tin locked up. It wouldn't. The developer could sit on its rights. It wouldn't have to develop the tin. It could speculate in the tin. It could affect use of the surface. It could enable. It could cause interference with mining of copper, which is often intermingled with tin. And the court ultimately said, we will recognize as reasonable this in common law the severance of a determinable tin estate, a tin estate for as long as tin mining continues, but we will not recognize a perpetual estate in tin that can go on regardless of whether it's being mined. In other words, in Rogers versus Brenton, the court recognizes in common law a tin interest that looks a lot like the civil law mineral servitude recognized in Louisiana, and it arrives at that in much the same fashion as it did, as the civil law jurisdiction did in Frost Johnson, which I find absolutely fascinating. Now, our time is rapidly fleeing from us, so I'm going to be extremely brief on this next part. But if you look at the history of water rights, you see the same basic pattern. In the original situation, we have a system of riparian law that says the right to use water in flowing streams and in lakes belongs to the owners of the land that connects to the stream or the lake. And in the case of Stockport Waterworks, it was held that a landowner's attempt to convey that water right away from the land and into the hands of a third party who doesn't own riparian land was ineffective, period. It could only give a license, which couldn't be enforced against third parties. In other words, the riparian right is inseverable altogether. There was an exception carved out in later case law for certain customary severances of riparian rights. Customary in the sense that, well, there's been a local custom to sever riparian rights away from the land to operate mills. That's been recognized in the law for a really long time as a custom, and we find that custom to be reasonable. So the court would allow severance for that purpose, and the famous case there is Nuttall versus Bracewell. In the United States, we have riparian law in the East. In the West, riparian law didn't make any sense because all the land was owned by the federal government. And so when gold mining and Western settlement in places like California and Colorado took off, courts had to determine whether water rights could be taken from non-landowners. In other words, could you go appropriate water in a stream to take it off site and use it for whatever mining or milling or agricultural purpose you might have, even though you don't own the land where the water is flowing. And the courts ultimately adopted what we now know as the prior appropriation doctrine out of a local custom of appropriation, whereby water was customarily severed by whoever appropriated it first. And this custom was, in a sort of long series of cases throughout all sorts of jurisdictions in the West, it was sort of adopted as the common law rule. And when courts were adopting it, they were considering its reasonableness. And then in considering it, they sort of added certain terms or massaged parts of the custom to make the appropriative right in water that the common law was recognizing reasonable in the common law. And one of the most important ways that they did that, looking here at my second big or third big bullet point, is that courts limited the appropriation interest, the appropriative right, to beneficial use of the water. So in order to have the right to water separate from riparian land, you had to be using the water for a beneficial purpose. And if you wasted the water, you lost your right. And if you ceased that beneficial purpose, you ceased using the water for that permissible use, then your water right would expire. In other words, the appropriative right in common law has a similar characteristic to this mineral law servitude and the tin mining right recognized in Rogers versus Brenton, in the sense that it can't be perpetual. You can't you can't own it without developing it. You have to continually use it for beneficial purposes. How did they do it? They started with custom. They looked at reasonableness based on a wide variety of facts and circumstances, but concerned about the consequences that we have been focusing on. And they have sort of limited the right that landowners or that can be obtained in land accordingly. So let's sum up here. What does all of this mean? I propose to you that on the estate severance question, there are two approaches in our law: a classical approach and a modern approach. The modern approach is where the landowner is deemed to be free to sever whatever rights he or she wants, and at least as long as that interest is analogous to an already recognized interest in land, courts are going to allow it. And the classical approach, though, which is more similar, I think, to the civil law approach of Louisiana, you have a closed system, no new property interests, unless there's a customary right that is deemed reasonable. And that often means, second slide here, that the kinds of interests recognized under these two approaches tend to differ. Under our modern approach, because landowners often want to convey perpetual interest, that's what they intend to do, and we just automatically give effect to it, the modern approach basically recognizes as the maximum interest a perpetual estate in each of these, which brings all those difficult consequences that has bedeviled oil and gas law for 150 years. In the classical approach, though, there's a whole variety of types of interests that the court may limit the landowner to. Some of them are perpetual. There at the bottom, I have an example we didn't talk about, but using the sort of classical customary reasonableness approach, that court allowed full perpetual severance of certain riparian rights in the submerged lands to build docks on. You have licenses and riparian rights. You have determinable interests in tin bounds. You have the use it or lose it appropriation right, and you have the mineral servitude. So this whole variety of types of property interests to suit the resource and the circumstances of the jurisdiction in that place and time is possible under this classical approach that our modern courts have essentially ceased to use. So that's the end of the slideshow. I do want to take, I don't know, maybe 5 minutes to look at some of the questions. In fact, there may be 0 questions. Those are chats unrelated to the substance.
There's one question.
There's one. What's our one question?
In Louisiana, under the code, how different is it to terminate partial ownership in a lease versus a common law jurisdiction?
In a common law jurisdiction, you ordinarily, it's much more difficult in a common law jurisdiction than in a civil law jurisdiction, because you ordinarily must first have some statute, like a Dormant Mineral Act or a Mineral Lapse Act, or maybe a Marketable Title Act, that enables the termination of an interest in a mineral non-consensually in the first place. Or you have to access the doctrine of abandonment or adverse possession to terminate it, which is very difficult to prove. And you have to show that the interest has ceased to be properly used or preserved under that special statute. In Louisiana, under liberative prescription, and I do not claim that I have an expert level knowledge on the practice in Louisiana here. The code already provides the basis for its prescription. It's lapsing, and what you must do is establish that the types of recognized uses in the mineral code have not occurred. And so you sort of have an easier go of it in that sense, perhaps. But as a matter of practice, I can't say. Now, when it comes to interests in mineral leases, most common law jurisdictions don't have a mechanism to terminate those for non-use. And I don't believe that the civil law allows specifically, separate from liberative prescription operating on the mineral servitude, I don't believe it has a mechanism for terminating an interest in a mineral lease for non-use in quite the same way. But I would, I'd be interested if you know of some authority otherwise.